So today I wanted to go over a common question that we get asked about. I have a friend of a friend who wants to invest in an investment deal that I have. Can I take them on? Am I allowed to do that? Or maybe it's a friend of an existing investor, but someone that they don't know. So I want to go over that a little bit. Let me share my screen. Okay, so friend of a friend. The question, I have a friend of a friend or a current investor. They want to invest in my deal, my fund, a securities offering. Can they? What are some of the legal issues in raising capital that this brings up? Under the Securities Act of 1933, your security, which is basically what you're offering in an investment, has to either be registered with the SEC or fall under an exemption for you to be offering it and selling it. Most private placements are done by companies or funds under Reg D, Rule 506. Generally, Rule 506 prohibits general solicitation. So what exactly is general solicitation? Which 506 is broken up into 506B and C. C actually does allow advertising and general solicitation. Most people raise capital under 506B, and that's been the most common one. So let me go over that one. So the general solicitation ban in Regulation D is under Rule 502C. Neither the issuer nor any person acting on its behalf shall offer or sell the securities by any form of general solicitation or general advertising. And that includes advertisements, articles, notices, communications, anything on TV, the radio, seminars, meetings where people are invited to attend by general solicitation. What exactly is general solicitation? There's no real definition, and it's a fact-specific determination. The SEC has issued different guidance that interprets it, but there's no set definition. And some of the guidance says that it includes advertisements published in newspapers, websites, communications on TV, seminars, use of any unrestricted and publicly available website can constitute general solicitation. And the solicitation must be an actual offer of securities, but also solicitations that condition the market for a potential offering of securities may be considered an offer. So if you have a website that says, here's our fund, or here's who we are, and we're sponsors, and we're looking for investors, or hey, we have future deals coming up. Hey, we just went under contract for this deal and we're going to need some equity. We're going to need some capital. That could be conditioning the market that you're about to have an offering of securities, and that could be a general solicitation and an offer. The SEC does allow you to have things like a website that says just factual business information. So if your website says, here's who we are, we're an independent sponsor, we put together certain types of deals for our fund, and this is a little bit about us and the type of deals we look for. Think about your current business model or facts about things you've done in the past, but no projections or forward-looking opinions, no forecasts, nothing about saying that you're seeking investors or looking for capital. That would be considered a general solicitation in most cases. And in some cases, talking about prior performance of an ongoing fund can be a general solicitation. So one of the key carve-outs or allowed things that will not violate general solicitation is if you have a pre-existing and substantive relationship with the issuer prior to any offer. Now, the issuer is the company that's selling the security, so the company raising money. That could be a fund, a newly created company, and the relationship would be with the sponsor or the people putting that deal together in most cases. So a pre-existing substantive relationship, this is where that question about a friend of a friend comes into play. Now, that relationship must exist with that potential investor and someone who represents the issuer, so maybe a sponsor or someone putting the deal together, prior to the commencement of the offering. And you can also not create the relationship with the intent of creating it just for this specific offering. So you say, I'm raising $5 million, here's our offering. Oh, I won't tell this guy about it yet, but let me go form a relationship with him because I'm going to tell them about this. If it's already existing, then it's probably not allowed. You can't create it just for that offering. If you don't have the offering going yet, you may be able to create it prior. And the SEC has said there's no set amount of time. I mean, it doesn't, they used to have a 30-day rule, but they do not have any rule in terms of it could be 2 days before, as long as it's not intended to create it just for this offering, but it can be created prior. And substantive relationships are where the issuer has sufficient information to evaluate prospective investors' financial circumstances and sophistication, basically to determine would they be an accredited investor or a sophisticated investor, which are some of the requirements under 506B, and checking the box by the investor or filling out a short investor questionnaire is probably not enough to know about the person's financial circumstances or sophistication to form that substantive relationship. So it has to be pre-existing, a relationship between the investor and the issuer or someone on their behalf. And it has to be substantive. You have to know about the person and their financial circumstances. So the application of this, one of the biggest things I tell people is just go with 506C. You know, basically you can only take accredited investors, and you have to take that step of independently verifying that they are accredited. But you can generally solicit all you want. You can advertise, you can put it on Facebook, you can put it on social media, as long as you comply with other regulations regarding it in terms of anti-fraud and things like that. But a friend of investor or someone you have a pre-existing relationship with probably is going to be considered a general solicitation. So a prior investor in a deal, you have a relationship with that person, that does not extend to one of their friends that you don't know in most cases. Now, if that friend or the person doing the introduction is a registered investment advisor or a securities broker dealer, that is allowed. That does create a relationship with that potential investor because of the fiduciary obligations of a registered investment advisor or securities broker dealer. So that can create a relationship, but that's one of the limited exceptions. Also, the SEC has issued guidance on pre-existing relationships can be created even with someone that you don't know if they're part of an angel investor network or some kind of similar private networking club or group. This is a very fact-specific inquiry because it looks at how many people are in the group. What does it take to get into the group? What do I know about the members of the group? You know, basically, is anybody let in? Is there 10,000 members and it's a private group in Facebook, but we don't know anything about these other people? Or is it a small limited group that you know have financial sophistication and it's a very tight-knit, close group? So some of it has to do with the size, but it's all about, the SEC says it's all about the quality of the relationship. So it could be a large group, but if you know these are, you know, multimillionaires that invest in large deals and they're very sophisticated and savvy, that might be okay, versus 20 people you don't even know and anyone is allowed in the group. So the bottom line is the issuer, who's the company basically raising capital, has to know enough about the investor's financial circumstances and sophistication to feel like the investor can understand the risks and nature of the investment. The SEC mostly cares about, well, a lot of different things, but one of the primary concerns is investor protection. So can the investor protect themselves to understand all the risks and the type of investment that you're offering? That's essentially kind of what these come down to when the SEC is now analyzing them. So I know that clients do let friends of friends in. You know, I'm quite sure they probably do. This happens in reality. It's not that this isn't a general solicitation. It probably is. It really comes down to whoever the issuer is, what is their risk tolerance? So some people feel okay, you know, violating different driving laws like speeding up to a certain point. So what is their risk tolerance of, okay, is this a general solicitation? Is it kind of a gray area? Am I okay with just going forward with it, if they're writing a big check, that's up to that person to decide. It might be cut and dry that, yes, that's a general solicitation, or it might be a gray area. So it's a really fact-specific investigation. There could be other exemptions you could use. There's a number of different exemptions besides 506B that might apply that could allow that solicitation or something else to allow that person in. Also, if you do let them in, it may be an insignificant deviation under Rule 508, which has a couple different things you have to comply with, where you don't necessarily lose your Reg D exemption under 506. If it's a small deviation and basically you didn't really know or something along those lines, but that, again, that's fact specific as well. So you don't necessarily lose your exemption, but you could if you don't fall under that sort of safe harbor of 508. So you could potentially lose your exemption, which means it's unregistered sale of securities, which could be enforced. Regulatory action by the SEC or a state securities regulator could involve things like charges of unregistered sale of securities, a number of different things depending on what happens in the case. It could be something as simple as a slap on the wrist. It could be prohibiting you from ever being involved in raising capital again in the future. And this might disqualify you from future raises. There could be rescission rights, meaning you have to give your investor back their money plus interest. So there are potential ramifications of this, even if you feel like you're willing to risk that. So best case is just go with 506C or talk to your qualified securities attorney about, okay, under these facts, do I think that this is a general solicitation? Can I take this person as an investor? If you have any questions, feel free to reach out. Thanks for watching.